Hello everyone, my name is Rachita Mathur, currently working as a legal intern at LEXCLIQ. So today I'll be discussing one case of Rajesh Vijayan versus Bar Council of India. So in this case, a petition has been filed before the Kerala High Court by a member of the Kerala Bar Council seeking a declaration that recently inserted sections 5 and 5A of Chapter 2 of Part 6 of Bar Council of India rules are unconstitutional and violative of Article 14, Article 19, Clause 1, Clause A of Subclause A and Article 21. The Bar Council of India had recently published a notification dated on 25th of June 2021 that adding sections 5 and 5A to Chapter 2 Part 6 of the rule, according to which a decision of any state Bar Council or Bar Council of India shall not be criticized or attacked by any member of Bar Council of India in public domain. The writ petition was being filed aggrieved by the addition to this provision which has the effect of inter alia prohibiting criticism and dissent against the Bar Council of India and other bar councils and demanding unquestioning acceptance of all the decisions taken by them. A petition has been filed by an advocate who submitted that the newly added rule infringed on the constitutionally protected freedom of speech and expression of the petitioner in his capacity as an advocate and as a bar council member. It was alleged that the rules are vague and consequently creating indisputable distress on public engagement and participation by an advocate. The petition also alleged that the said provision are violative of the decisions of the Supreme Court which have been laid down the legally permissible restriction on freedom of speech and expression. It was also submitted that in a petition that these rules prescribe a procedure for proceeding against the advocate and bar council member which violate the basic principle of natural justice by publishing them in the gazettes of India. It was alleged to be an attempt to inhibit the exercise of freedom of speech and expression by an advocate and bar council member, although the statutorily mandate the procedure for giving effect to such rule has not been fulfilled. Further, additionally, the petition highlighted that Section 5A prescribe a procedure for declaring an advocate or bar council member as disqualified to contest the election of any bar association or bar council. However, in this procedure, it has been stated that the Bar Council of India shall take its decision after the consideration of the report of the committee. This implies that the final decision is being made by the Bar Council of India itself, which was being condemned by the petitioner. Furthermore, it was submitted that the first proviso to Section 49 Clause 1 of the Advocate Act mandate that no rules made with reference to Section 49 Clause 1 subclause C shall have the effect unless they have been approved by the Chief Justice of India. However, the said notification does not disclose if any approval from Chief Justice of India has been obtained for Section 5. The Bar Council of India has not yet clarified as to whether or not it has been obtained approval from the Chief Justice of India with respect to Section 5. At the outset, without fulfilling this statutory requirement, Section 5 can't be given effect to. However, the impression that has been widely reported and conveyed in the legal and general media is that with the publication of this said notification in the Gazettes of India, the newly introduced section have come into the operation. The petition expressed a grave concern given the drastic penalty that have been prescribed. It was submitted that in the absence of certainty as to whether or not Section 5 is currently in effect, it is likely that many persons will exercise self-censorship, thus leading to a classic case of violation of free speech and expression. On this ground, the petition sought to be declared aforementioned provision unconstitutional and illegal. It was argued that the work and subjective standards adopted in sections 5 and 5A to determine what is permissible speech violate the petitioner right under part 3 of the constitution and also deviate from the decision of Supreme Court. The petitioner also submitted that the demand for unquestioning agreement with the decision of bar councils is violative of the constitutional right. Accordingly, it was prayed that the court issue a writ of mandamus or any other direction declaring the sections 5 and 5A of Chapter 2 of Part 6 of the Bar Council rules are violative of Article 14, Article 19 Clause 1 of Subclause A and Article 21 of Constitution, and a declaration of this provision can be given to effect only after obtaining approval from Chief Justice of India under first proviso to Section 49 Clause 1 of the Advocate Act. Meanwhile, petition also sought an interim relief to stay the operation of this provision and to restrain the respondent from taking any coercive action or step which are pursuant to this said rule pending the disposal of this writ petition. That's all for the day. Thank you.